And it's working.
We're going to hold Officer Reggie Thompson about his immediate soon, and once he comes, we will get started in immediate improvement. And that's what Jackson and Cindy, all these folks who stand here against. There's some nameplates on the ground. Definitely, please look down. There's some nameplates on the ground.
All right, we are back on. Members are present, represented by counsel.
If you don't see anything there, you're standing in someone's spot. So put them up with your family. Come on, let's give it up for
Mr. Gall.
Your Honor, after pondering over the lunch, talking with co-counsel, and with all due respect to them, on behalf of Mr. Bryan, I am moving for a mistrial at this time based upon the question posited to the witness in the presence of the jury in this case. I'm not going to belabor the comment itself. I'm not going to belabor the comment itself. I think co-counsel have already addressed that, and the state has already provided their explanation for it. But I think the best way I could characterize it, the question would be the way another argument in this case was characterized as being reprehensible. Not the person, but the statement. We're asking for a mistrial at this point because we just don't see any way that that issue can be cured. And part of the reason I say that, Your Honor, is, it just brings all kinds of different problem issues in this case all together in a way that creates a puzzle. And I don't see, with all due respect to the McMichael defendant's counsel, I don't see how we unring the bell, how the jurors unhear what they heard, and I don't know how the court cures it without bringing more attention to other issues. I mean, I thought the state was all concerned about talking about punishment and penalties and stuff. I thought this was an issue we discussed before trial, and I don't know how the court addresses this to the jury without bringing attention to punishment issues in the case. It's just unfortunate, and obviously it was arguably intentional in the question itself. It wasn't, we've already heard a statement, it was not an accident, it wasn't a misspeak of words, it was intentional, and we think that a mistrial is the only remedy under the circumstances.
From the other defendants on the motion.
We are waiting to see what you do about our motion to admonish and a curative instruction.
I agree with Ms. Hogue.
From the state.
We leave it to the discretion of the court.
All right. Yeah, the court indicated that I'd take the lunch break to think through exactly what to do. The court does find that the question that was presented was inflammatory and irrelevant and completely unnecessary, particularly given the witness that was on the stand. It has potentially injected into this case issues not appropriate for the jury and which were in fact discussed and brought up pre-trial. Counsel should have either known or should have known that this was a question that should not have been asked, and therefore counsel is admonished by the court and is instructed not to repeat such actions subject to the contempt powers of the court. The court does in fact, or will, instruct the jury that the state has been admonished based on the question. I'm not going to repeat the question. And I'm going to instruct them to disregard the question asked and any implications arising therefrom. That is the intent of the court. The motion for mistrial is going to be denied, with the court finding that the admonishment is the appropriate remedy and the instruction to the panel addresses the matter presented.
And just for the record, Your Honor, the court's going to do this in front of the jury, and I just don't want to be perceived as having waived by failing to accept. I'm just putting on the record that we do not believe the curative instruction will be sufficient. If the court wants me to come back up and say that again after the court actually does it, I can do that, but in the interest of efficiency, I'm just asking if the court will recognize this, preserve the motion for mistrial notwithstanding the curative instruction, or does the court want me to get up again and renew it after the curative instruction?
As far as the court is concerned, the court's ruled on the mistrial, and I have, I guess, pulled the motions together. I am I've admonished the state, indicated the court's position with regard to the question, indicated that the contempt powers of the court would be the next remedy available if such action was taken, and I will indicate to the panel that the state has been admonished as such and instruct them to disregard the question. So that addresses both the motion from the McMichaels as well as with the court denying the motion for mistrial, will instead be providing the instruction that I have just indicated.
Thank you.
Anything from the state before we continue? Actually, it's the defendant's case, Chief. Anything from McMichaels before we continue?